And I'm going to kind of just turn the time over to Justice Lang. We're so grateful to have you and your colleagues here. And welcome, everybody. We'll get started. Go ahead, Justice Lang.
Okay, thank you very much. Um, it's an honor for us to be here, and I'm not going to use up a lot of time talking about thank yous, except I want to thank Dean Wilcox, Elizabeth Chambliss, Director of the Center, John Montgomery, Sharon Williams, and especially Nelson, Mullins, Riley, and Scarborough, our benefactor, have done this. And our friend over here, Ed Mullins, who got his firm to come in and make this happen. So it's been terrific. On my right, U.S. District Judge Joe Anderson, senior status. He's been chief judge of the district here in South Carolina. You can read the rest of it. And on my left, Bill Koch was on, Joe's been on the bench for, I guess, 31 years. Bill was on the bench for 30 years before he became dean of the Nashville School of Law. He was on the Court of Appeals for, I believe, what do you call it, the Middle District of Tennessee, or that's close enough to say it, and then on the Supreme Court for some time. Bill is currently the vice president of the American Innocence Court Foundation, and we have served on the board. These gentlemen are terrific. We won't keep you here past 5 o'clock tonight, but we do have 20 minutes, so we're gonna move, and we kind of carve this down. What we're going to kind of talk about is perspectives and things that we haven't really necessarily heard as a consistent thing about what is the essence of what we're doing. What we're going to talk about kind of pulls together everything that we've heard last 2 days. To me, and I've been learning about this and started to preach it, and I think they do too. We're talking about helping these beginning lawyers develop their moral compass. Their moral compass, which means they quit worrying about themselves all the time and they decenter, as a friend of mine who's a professor of philosophy says. That is critical. We'll talk about that. The wellness discussion yesterday was so critical to helping me think about things, how we can be a joy multiplier, but when people get ill, various reasons, they're robbed of that joy. And so we need to help them get some joy in their life. Of course, we know that we are working to change the culture. We talk about values of the profession, but what I've been contemplating, especially with the help of this professor of philosophy that's really made me think, we have values where we came from, whether it's religion or family or culture, wherever we came from, and we have those values. And I've seen, unfortunately, from my perspective, seen too many lawyers say, I'm leaving those at home when I go to the office. But Ida and I were talking, they're all one thing. And we have to tell them, like I have in recent days speaking to students, I'm going to talk to you about rules, but I'm really going to talk to you about your conscience. So I think that's really where we're going to come from a little bit. We all agree that we instruct professionalism when we mentor. But Bill, as Dean of a law school, working with so many people that are like us when we were in law school, just trying to figure out the next day. I mean, can we really teach it? How do we do that in law school?
Well, it's probably not helpful to have a how do you act like a lawyer 101 course with a final exam. That usually is not going to be productive. But we actually start on the first day of orientation and our message is first to affirm a student's decision to pursue law and to discuss how noble the profession is, and to reinforce with them that they are beginning essentially an apprenticeship to become lawyers, and that lawyers are expected to act differently than everyone else. They have different codes. The first lunch of the first day of orientation, our students stand up before a Supreme Court justice and take a professionalism oath. And they sign it, the justice signs it, they're provided a copy of that, and they frame it, and actually many of them hang it in their bedroom. So you know, our message is that this is a different enterprise that you're embarking, and that there are things you should do and shouldn't do. And I think the other thing we point out to them is that professionalism and ethics are two different things. Sadly, our profession has reduced the rules of professional conduct to the black letter minimums about what you can do without getting into ethics jail. And so we tell them there's a real difference between asking yourself, what am I allowed to do, versus what should I do? And I think that's what Doug's talking about, that what should I do question is something that I think lawyers throughout their careers have to ask. Judges have to ask the same question. So I think that is instilling the importance of that question in their mind.
Well, you've had, how many, 60, 70 law clerks over your career. They're right out of law school. And what's your approach on that, with people of that caliber?
Well, I think creeds and so forth are very important, but I've always believed in role modeling. I had a trial last year, and Carl Solomon, a very fine lawyer here in Columbia, was arguing to the jury, and he told the story his mother had told him, I'd rather see a sermon than hear a sermon. And he used that theme in arguing to the jury. And I think I didn't realize until last night at the cocktail party, speaking with Dean Wilcox, he pointed out that for lawyers of my generation, I went to law school in the 70s, and in South Carolina, up until about that time, the practice of law was a closed shop. You were the son of a lawyer and went to law school, and the mentoring kind of policed itself. And then in the 70s and 80s, we had a lot more diversity, a lot more first-time lawyers, and no role model to grasp hold of. And so I've always tried to nurture my young law clerks along, and I hope I've done a decent job at it. But I think role model is important.
I want to ask you to take a look at this, and it's in your book, and I was struck by this. My philosophy professor gives me a lot of stuff to read, but Peter Short wrote this: mentoring work is towards releasing what is there. That is, providing the actor, he calls mentees actors, with the opportunity to act. He also said, our education is not for us, it's for others. That concept to me is very important. Releasing what is there. We don't make it. What do we do while we're trying to help them, what should we do about equipping these people so they can act, but also to understand what it means if you lose a trial or an appeal or a deal goes bad? What do we do? That loss. How do we help them on that? Bill? Joe?
Well, I think part of being a professional is learning how to lose the right way. You're definitely going to lose. I can remember the first time I thought I got an unjust result, and you just have to take it in perspective. Many times, what you realize is it's a shortcoming of your own. So part of what I think we try to instill in the students is you're going to stumble. And the question is, what do you do after you do? And professionals, the first thing they do is they own it. They don't start looking for somebody else to blame. And then the second thing they do is they need to sit down and do a very careful inventory of what could I have done differently or better that would have affected the outcome of that particular thing. And we actually, a lot of our students now, we encourage them to, when they take final exams, we have the exams with the answers available, and we say it for a learning exercise, go in and look at the model answers, compare them with your answers, and learn where you lost ground. It's absolutely stunning to me that maybe 25% of people take the opportunity to do that. The rest just say, well, I got an 85, so I'm happy. I'm going to get out of that course. So I think part of it is teaching folks what to do when they do stumble.
Joe, your thoughts with, for instance, your law clerks observing the trial and people have worked hard. I mean, do they get it? Is that a lesson they understand?
I think so,
You
yeah.
know, we all, the old saying goes, anybody that tells you they've never lost a trial, they hadn't either tried very many or they settled all the bad ones and only took the good ones.
That's right. That's right. You know, I think it's a lot to be said for trial observations. Regrettably, as we all know, the number of civil cases going to trial is in a sharp decline, so there's less opportunity for young lawyers to watch good courtroom advocacy at work. But my law clerks get a ringside seat to see it. And as I said, it's a zero-sum game when you try a civil case. Usually, sometimes the jury puts it down the middle, but usually there's a clear winner and a clear loser. I always look to see if the lawyers shake hands in front of the jury when the verdict comes in. I don't have a rule requiring it. I've thought about it, but I remember that's something my father taught me. No matter how you come out, go and shake hands with your adversary once the case is over and the dust is settled.
I think that's classic stuff that we need to pass on. I tell my law clerks, you don't have to sit in your chair the whole time. You're watching oral advocacy, but I want you to go to my friends in the trial bench and go see what goes on and learn about the fact that you're going to get kicked around. It has occurred to me with Professor Frank about the fact that we probably need to talk more with the beginning lawyers about the fact this mentoring program is not just for you. It's for you to pass it on, like all of us are doing. Go out there and pass it on. It's like he said, to make man reasonable is to make him sociable. No man can be educated for himself without being educated for others also. Bill, do they get that, do you think, in law school? Is that something that we can help them with?
You know, my experience has been that different states and different legal communities have different cultures about some of this. And for example, if you were to go on Google and search on Tennessee lawyers and mentoring, you would find a long list of jurisdictions that said we don't have any, we don't have any, we don't do it, we stopped it. So formal mentoring programs in Tennessee simply have not taken root. And so what we've done at the school is we're sneaking it in through the back door. You know, for example, our rigorous writing requirement is a legal mentoring program where we've recruited 150 lawyers and judges from around the state who agree to be writing mentors and supervise one student in the preparation of a major paper. Our trial advocacy classes, we just finished our criminal trial ad class middle of this week. 24 students, 18 lawyers volunteering to be mentors. The instructor is a criminal court judge, and they had their final cocktail party is the way they wanted to do their last class. I had to get special permission to do that. And again, what they're learning to do is work collegially with other people, and these are other lawyers they're learning to work with, and so they learn that skill. So, but we don't call that mentoring. You know, we just say they're all part of your program to help you give critique on how what you're doing right, what you're doing wrong, but we don't hang the word mentor on them because that, at least in Tennessee right now, that starts to create a barrier.
I'm going to go quickly to the next things, and I want to ask Judge Anderson about this. Dean Montgomery put together some numbers after being authorized by the Supreme Court of South Carolina, showing the number of sanctions imposed on lawyers in practice 5 years or less, up through 15. And you can see on the second page, I'm going to show you about, the pilot program started in 2006, mandatory program, second program, and then look back at the numbers. And you got any ideas about how we can all use this?
Those numbers tell quite a story, don't they?
Yeah.
I had not seen those till this morning, but we do have a robust mentoring program in South Carolina, all the way up and down the line at law school. The one else are paired up with mentors. The John Belton O'Neill in the court has a very successful, long-running mentoring program. We've got the Nelson Mullins Professionalism group here. Ed Mullins helped kick that project off, 10, 15 years ago maybe? And it's just done a wonderful job of working with the law school and the bar to have a real structured, formal mentoring program. And the numbers don't lie.
And I know Dean Montgomery and I are various places around the country, and I've seen professors challenge us and say, well, how do we know this mentoring stuff works, has any effect? And then when John was able to put these together, the advocacy I've used on it is to say, with some doubters in my own state, I said, look at these numbers. I can't tell you that this is the cause, but I can tell you that people come, take the bar, and they come from all different backgrounds, diversity, all values, law schools, and the one thing I can think of that they've got in common is this mentoring program. So, I would, my personal view is this is persuasive, just as Judge Anderson said, and maybe this is something you can use. Quickly, before they get the hook and pull us off, there are a couple new programs that I've been talking to Bill about. And Bill, you were talking about one in Chattanooga Bar?
The Chattanooga, actually it's the Inn of Court in Chattanooga in conjunction with the bar, developed a civility professionalism card. You have it on you?
Yep.
It's a credit card size card that has a professionalism civility oath on it, and it's distributed to every lawyer practicing in Chattanooga. And I chair the vacancy commission for the state, where we fill vacancies in judgeships. And about 3 or 4 months ago, there was a vacancy in Chattanooga, and we have 15 or so people applying, and there's public hearings, and they testify, and then we ask them questions. And one of the applicants had put on his materials that he was a former member of the Inn of Court in Chattanooga. So I figured I'd just ask him if he was familiar with this card. It started doing it about 2005. And he was standing there at the podium. He says, yes, I carry it with me. He pulled it out of his shirt pocket and said, I carry it wherever I go. So that's a pretty novel thing.
And you said that man has got to be a winner.
Yep.
Yeah.
He didn't ultimately win. I think he did make the final 3, but the governor picked somebody else.
Well, you get another shot. Real quickly, one that a couple of friends of mine have started is just to raise the visibility of civility and professionalism. The Dallas Bar and then the State Bar, the Supreme Court, Court of Criminal Appeals have all come together and sponsored a Day of Civility, celebrating civility in the legal profession. It's next Friday. And metropolitan bars and county bars across the state are taking this up. And it's not that anybody's going to become civil after going to this afternoon program, but everybody's going to haul their young lawyers over there. And there are going to be 300 or 400 people at the Dallas Bar headquarters. And the whole idea is you get people up there talking about it, judges, lawyers, you name it. And so everything helps, as we know. Well, let me close if I can find it. with a very quick story. A wonderful lawyer passed away a few years ago, was a mentor of mine. He was the dean of the African American lawyers and a great guide for all of us. Just a very humble man, but very strong. As he said to me one time, I may be nice, but I'm not easy, Doug. He told me this story about W.J. Durham, and I've been passing it on. W.J. Durham was an African-American lawyer. They couldn't go to, folks of that ethnicity could not go to law school in Texas until the late 60s. He was a tremendous trial lawyer. He went to East Texas, where some people had a little bit narrower view of what ought to go on at that time. And he was appearing at a docket call in a criminal case. And the judge started giving him a hard time. Well, you licensed practice law here, sir. I mean, on and on. And another lawyer got up who knew it, a big Caucasian fellow. And he said, I know Mr. Durham. He's an outstanding lawyer. And Your Honor, I will vouch for him. The judge kind of went away. But L.A. Bedford, my friend, Judge Bedford, said, that's what Durham told him one time. Be great, be good, be civil, but don't ever let him see you sweat. And that balance is so important. Well, guys, thanks a lot. We're, I don't know, they didn't take the hook, but we're 2 minutes over. So thank you so much.